you indicated earlier that the Legislative Reference Bureau had previously withdrawn the date of publication from the document. Is that correct?
Yes.
And that is in response to the temporary restraining order issued by this judge. Is that correct?
Yes.
So at the time that you received the letter from the Secretary of State and the temporary restraining order from this judge, it was the perception of the attorneys in the Legislative Reference Bureau that you should obey the court's order.
We were not planning on publishing on that, our role in publishing on that date. Yes.
Did you remove the date March 25th, 2011 from the document?
Yes.
And that was because of the restraining order that was issued by Judge Sumi and the letter that you received from the Secretary of State?
Yes.
Now, you indicated that you've worked for the Legislative Reference Bureau since, was it 2007 or 2008?
1998.
Oh, I'm sorry, 1998.
Okay.
During the time that since 1998, when you worked in the Legislative Reference Bureau, have you ever before been aware of an instance where the Legislative Reference Bureau, independently of the Secretary of State, designated a date of publication?
No.
Now, at the time that you were discussing this matter with Senator Fitzgerald, did you discuss with Senator Fitzgerald the provisions of Section 991.11 with stats?
Yes.
And did you explain to Senator Fitzgerald, or did anybody offer the legal opinion to Senator Fitzgerald that the provisions of Section 991.11 provide that a date is that publication, or I'm sorry, that an act of the legislature becomes effective the day after publication as directed by the Secretary of State?
Yes.
That is what the provisions of Section 991.11 provide, isn't it?
Yes.
And did you advise Senator Fitzgerald of that fact?
We told him we didn't know what the effective date would be if the bill were published on March 25th, given that provision.
Now, at the time that you did ultimately, or somebody from the Legislative Reference Bureau authorized the posting of this bill on the Wheeler report, who was the one that decided to add the asterisk and the dagger, which I understand the technical term is an obelus? Is that correct?
We thought it was dagger.
Oh, okay. Well, if you look at Wikipedia, the dagger comes up as obelus, just for future reference.
I'll let editors know.
So it's an asterisk and a dagger, and who had decided that this asterisk and the dagger should be added after the date of publication?
We decided we needed more information.
When you say we, who are you talking about?
I believe I started the conversation because we weren't sure what date should go there. Someone suggested no date. Someone else said that's never happened before. We said, well, we'll put March 25th on there, but we believe that we should alert a reader that there's something else going on.
One moment, please. Now, are you aware of Section 13.92 LRB, Parent 1, Parent B, which provides, in performance of its drafting services, the Bureau shall, and then subsection 4, publish each act on its date of publication. And then underneath that, upon receipt of notice from the Secretary of State under Section 14.3810A, the Bureau shall enter the act number, date of enactment, and date of publication of each act on the camera-ready copy and deliver it to the contract printer for reproduction. Are you familiar?
Is this an administrative rule?
No, this is a state statute.
Oh, I'm sorry. I thought you were referring to an LRB statute.
I'm talking to...
Go ahead.
Are you familiar with that statute?
Yes.
Do you need me to provide you the copy? I don't have a statute book here, but do you need me to provide a copy? And in fact, didn't you review that statute at the time that you were speaking with Senator Fitzgerald?
That one wasn't one of them that we were discussing at that moment, at the meeting.
Well, you do recognize the provisions of that statute.
Yes.
And you do acknowledge that in the history of the Legislative Reference Bureau, insofar as you have been there, the Legislative Reference Bureau has always followed the provisions of Section 13.92, subparagraph 1, subparagraph B, subparagraph 4.
Yes.
Because that's the law of the state of Wisconsin, correct?
Yes.
And also, As a public officer in the state of Wisconsin, when you receive a restraining order from a judge restraining the further implementation of an act, don't you think, as a member of the Legislative Reference Bureau, you, like every other citizen in the state of Wisconsin, is subject to the provisions of a restraining order, directing you to not take any further action?
To rephrase the question.
Let me get the restraining order here. Do you acknowledge receiving an order granting a temporary restraining, the order granting a motion for temporary restraining order signed by this judge, reflecting that it was enjoining defendant Secretary of State Douglas LaFollette in his official capacity from publishing 2011 Wisconsin Act 10 until further order of the court is granted? You received that order.
Yes, we received a copy of it.
And you are aware that under section 13.92, subparagraph 1, subparagraph B, subparagraph 4 of the statutes, the Legislative Reference Bureau is only authorized to enter a publication date on a legislative act upon designation by the Secretary of State. Isn't that true?
Yes.
And you were aware that the Secretary of State had sent you a letter rescinding the previously designated publication date. Isn't that true?
True.
And you advised Senator Fitzgerald of these facts?
Yes.
And was Senator Fitzgerald nonetheless very insistent that this legislation be published on March 25th?
He,
Objection, Your Honor, and this is part of the objection that Senator Fitzgerald was not present here today to advise me whether or not the conversation is correct and to direct me as where I should be correct my question. And I realize that's definitely to objection. It is, and you can recall this witness when Mr. Fitzgerald comes back to court, but for now the objection is overruled.
That means you can answer the question. Did you need it to be repeated?
yes, please.
I'd request the reporter read it back.
He requested that we publish it.
I didn't ask you if he requested it. I asked you if he was insistent that it be published on March 25th. Did Senator Fitzgerald insist that the Legislative Reference Bureau publish this act with a publication date of March 25th, 2011?
I'm not sure your distinction between request and insist.
Well, I'm requesting you to answer the question, and if you don't, then I might ask the judge to insist that you answer the question. Do you see that distinction?
He is our boss, so a request from him would be something on the level of insisting.
Well, you know, we have other bosses in this room. The district attorney is a boss, and these people have bosses. The Secretary of State is a boss. Do you think it's appropriate for a boss to insist that its subordinate do something that is inconsistent with the law of the land?
I wouldn't think that would be appropriate, no.
Now, you are aware that the law of the land is set forth in section 13.92, subparagraph 1, subparagraph B, subparagraph 4, which indicates that the Legislative Reference Bureau is only to enter a date of publication upon receipt of notice from the Secretary of State.
We believe that section 35 says something different.
Well, if section 35 authorizes you to enter a date of publication, then there really is no need for an asterisk and a dagger after the date of publication. Now, is there?
That's why we added it. There's some ambiguity that we could see.
Where is the ambiguity in section 13.92, subparagraph 1, subparagraph B, subparagraph 4 of the Wisconsin statutes, which indicates that you shall only publish each act on the date of publication upon receipt of notice from the Secretary of State under section 14.38, parent 10, parent A? Where is that?
We had received notice.
I think there is an objection from each council on this particular
What is
question.
the objection? Ms. Lazar first.
The objection is that this is ask and answer, and it's almost harassing.
Mr. Fallon?
Our objection concerns this. The court is the arbiter of the law, and we will decide whether the statute is ambiguous or not. And necessarily the opinion of this witness is not binding.
objections are both sustained.
Well, at the time that you were speaking with Senator Fitzgerald, did you make him aware of Section 13.92, subparagraph 1, subparagraph B, subparagraph 4 of the Wisconsin statutes?
I don't remember that exact statute being the subject of the conversation. I'm
Well,
sorry.
Okay.
I don't remember.
And what I'm trying to understand is, in response to the senator's request that you publish this act, clearly somebody from the Legislative Reference Bureau was expressing sincere reservations as to whether or not you could lawfully do that. Isn't that true?
We were expressing reservations about what the effective date would be.
Because of the provisions of Section 991.11
Yes.
and 13.92, subparagraph 1, subparagraph B, subparagraph 4?
Again, I don't recall discussing 13.92.
Do you remember discussing the temporary restraining order that was issued by Judge Sumi with the Senator Fitzgerald?
I'm sure it came up. I don't know in the context of this moment.
Do you recall Senator Fitzgerald offering an opinion to you regarding Dane County judges in general, or this Dane County judge in particular? Your Honor, I think that it is relevant that Senator Fitzgerald, I saw him on television myself, designating this court as a liberal Dane County judge, and the liberal Dane County judges as not being able to intrude upon the legislative process.
Right, counsel, don't testify. The objection, though, is overruled, and you may answer the question.
I've heard the statement too, and I don't recall whether it was said at the meeting or not.
But you do recall hearing that statement from Senator Fitzgerald?
I recall hearing similar statements.
One moment, Your Honor, I wish to confer with my client before I proceed.